Hello, everyone. This is Roger Royce. I'm a partner with Haynes Boone in downtown Palo Alto and also host of the 10,000 Startups podcast, where we periodically will bring you updates on issues of interest. Today, I want to talk. I was just sitting here tonight reading the chatter about this recent case, the National Small Business Administration versus Yellen, where a court in Alabama ruled the Corporate Transparency Act unconstitutional, on the basis that it just can't be justified as an exercise of Congress's enumerated powers. So as you know, if you follow my podcast, we had just done an episode on what the CTA is and how to comply with it, etc. So it's kind of timely that as soon as I release that, a court in Alabama finds it unconstitutional. Well, I want to talk a little bit about what I think that means, because there certainly has been a lot of discussion about it. So now you may know, as you recall from listening to my podcast, this 2024 is the first year that the Corporate Transparency Act, the CTA, came into effect. And basically, it requires U.S. businesses or businesses doing business in the U.S. to file beneficial ownership reports with FinCEN, Financial Crimes Network of the Treasury Department, Financial Crimes Enforcement Network of the Treasury Department, FinCEN. And recall that this was enacted back in 2021, and the whole purpose of the bill was really to discourage money laundering and other sorts of nefarious activities, because let's face it, the U.S. has basically become a secrecy jurisdiction. I know I've run into that problem myself, where you really don't know who owns the company that you're dealing with through any public record or anything like that. You still don't, but under this law, because of these filings that are made every year, FinCEN does. So if there's something illegal going on, illegal activity, tax evasion, etc., the idea is they would be able to find out and certainly discourage that, or at least keep the United States from being a secrecy jurisdiction. Well, so in this case in Alabama, the NSBA, National Small Business Administration, they challenged the law on constitutional grounds, on quite a number of constitutional grounds. First, Fourth, Fifth, Ninth, and 10th Amendments. The court didn't have to get to those because the court there invalidated the law based on the Commerce Clause. And so recall that the Commerce Clause, it really has two things. It's a very simple clause of the Constitution. It says that Congress shall have the power to regulate commerce with foreign nations and among the several states. And the courts interpret that to mean that two things. One, Congress has the power to regulate interstate commerce, but then secondly, matters that are solely of intrastate concern are not within this clause. The Constitution also has what they call a necessary and proper clause that implements these powers and says that Congress shall have the power to make any laws which are necessary and proper for carrying into execution the foregoing powers. Okay, so we've got those two things. Well, again, the way the cases have come along, remember Obamacare, that case 10 years ago, is that there really has to be an interstate commerce concern here before there can be, in this case, the court said, before there can be any nexus to any enumerated power of Congress. In fact, the exact quote from the judge in Alabama is that the CTA exceeds the Constitution's limits on the legislative branch and lacks a sufficient nexus to any enumerated power to be a necessary or proper means of achieving Congress's policy goals. Now, note that the court said those are definitely legitimate goals: discourage money laundering, tax evasion, etc. Those are definitely legitimate goals, but that's not enough to make an act constitutional. An act might be a good idea, but still unconstitutional. Now, what are we focused on here? The act requires reporting of the simple act of corporate formation, and then sometimes changes in that ownership structure. And the plaintiff's argument is that, look, federal governments don't form corporations, states do. And this is purely a matter of state concern. And the government said, well, wait a minute, we're in the real world. We know that corporations, they might form in Delaware, but they're going to do business all across the country. That's interstate commerce. And interestingly, the court said, yeah, they might, and maybe they even usually do, but they don't have to. And the fact that they could do interstate commerce isn't enough to give the government the license to regulate those companies cradle to grave, just because they might engage in particular transactions. And those are the words that they use. So it's a pretty narrow or expansive, depending on how you look at it, application here of the Commerce Clause in this scenario. So anyway, the court found it unconstitutional. I guess it's a narrow view of Congress's power and a narrow view of the Commerce Clause power. Now, these other arguments of the government didn't go anywhere. They said, look, this beneficial ownership is vital for national security, to fight terrorism, but the court said, yeah, maybe, but even those powers don't extend to matters of purely internal affairs of a state. So where does that leave us? So what happened is the court enjoined the government from enforcing the CTA against the named plaintiffs in the case. Well, who is that? The National Small Business Administration has 65,000 businesses in all 50 states. So what does this mean? And certainly some practitioners view this as meaning it only applies to the plaintiffs in that case, and that is the announcement that FinCEN has made. Other practitioners are saying, look, it applies to everybody. We're not going to file these reports. Keep in mind that the government has appealed. Who knows where this will go on appeal? There could likely be other cases. In fact, I'm sure there will be following this in other district courts. They might go the same way. They might go a different way. So we just don't know. What we do know is that FinCEN has said that it is going to honor the court's judgment, and it is not going to apply this law to the plaintiffs in that case. Well, by implication, to me, that sounds like they are going to apply it to everybody else. So what I'm counseling clients is that you should definitely continue. You should comply with the CTA. Get your filings in. Keep in mind that if, recall the rules, if you're formed before the effective date, before this year, you've got a year to get your filing in. If you're formed in 2024, you have 90 days from formation to report. And if you form next year, you got 30 days. But I've been on the website. It's not a difficult filing. It's easy to do. There's no real reason why anybody really should push back on doing this. And of course, you may even be exempt. Keep in mind, there's 23 exemptions from this. For example, if you have a U.S. office and 20 employees and $5 million in gross receipts, you may be exempt from this law. That is not many of my startup companies. This is aimed squarely at you, new small companies. And there are other exemptions for highly regulated businesses. So it's worth looking into. There's likely going to be penalties at some place for not filing. So my recommendation, despite this case, keep an eye on the case, keep an eye on what Congress does, what FinCEN does, what the courts do. But in the meantime, I would certainly get the filings in. This is Roger Royce, Haynes Boone, Palo Alto. Thanks for listening.